Hi, and welcome to Quimbee. And today we're going to talk about attorney's fees, the legal rules of the road. Here's your course description. New client and wondering how to handle the fee arrangement, retainer, contingency arrangement. What's a lawyer to do to ensure reasonable collectible fees? Driving business is a necessary part of the practice of law, and the legal ethics rules of the road are an essential part of the roadmap. This course will explore the fundamental categories of fees, reasonableness, methods of fee collection, trust account issues, and more. Here's your learning objectives. Analyze the standards for determining reasonable fees, explore the different types of fees, identify various billing issues when outsourcing work, understand the permissible methods for sharing attorney's fees, and recognition of fundamental trust account issues. Sounds like a lot, but I think it will become much clearer as we go along. So let's go through some of the basics first. And I'm going to refer to some of the notes or outline that you've been provided. So we're sort of moving along together. If you, what we're considering here is in most states and in the model rules, Rule 1.5 and Rule 1.5 tells us that legal fees must be reasonable. And so, of course, we love that standard in the law, reasonableness, but standing alone, it's hard to understand the application sometimes. So let's break it down a little bit. What is the difference between reasonable and unreasonable? And let's say first that reasonable attorney's fees, it's great if you have them in writing, if you're challenged on the concept, but in many states, a retainer or an engagement agreement is not required to be in writing unless it's a contingency fee agreement or it's a very limited scope of representation agreement, or perhaps it's a non-refundable fee arrangement if your state allows it. So if your state allows it is always important to know. Make sure you know what's required in your state. If your retainer agreement is required to be in writing regardless. And even if it's not best practice, definitely put it in writing. And if you don't do it in the moment that you talk to a client and agree to do something, your relationship with that client is likely begun. Do it after the fact. Discuss it with the client, put it in writing, have the client review it. So that's point one. But what are the factors to determine that it's reasonable? And so what the courts have looked to and the ethics bodies have looked to are certain factors. They'll look at what is the time, labor, and novelty of the case. Is it a simple speeding ticket and your law firm processes hundreds of those a day? Or at the other extreme, is it a novel issue of law for which there's no exact precedent? The next one is the likelihood that the lawyer will be precluded from other employment while pursuing the case, along with special time demands. So, especially if you're a small firm or maybe even medium size, is this case so large that taking it on is really going to preclude you or the firm from taking on other matters? What are the customary fees? So I'm sitting today in Miami. What may be customary here may not be customary even in the state of Florida, in a town further north of here that's maybe a small town where they've set different fees. Certainly in different states and in different parts of different states know what lawyers generally charge for a certain matter. So if it's after the fact and it's a debate on whether your fees were reasonable, a court may look at not only the size of the case, but what were the results you obtained.